It makes sense in talking about the constitutional text to talk first about the structural constitution, the pre-Bill of Rights Constitution, and the grants of power it makes to Congress, and then second to talk about restraints on congressional power and state power in the Bill of Rights and in Section 1 of the 14th Amendment. I think the Constitution's primary guarantee of individual liberty comes from the fact that it sets up a complex federal republic with an elaborate system of checks and balances, which makes it hard for transient democratic majorities to take away individual liberties or property. The point is so well made by James Madison in his various Federalist Papers that I think it's sufficient to just mention Madison on this subject, and since I'm sure you all know his arguments very well. The next thing that's important about the text of the Constitution, in my opinion, is that it creates explicitly a federal government of limited and enumerated powers. In a case involving the application of federal law to a U.S. citizen, the federal government therefore has to act within its enumerated powers. There are, of course, two such powers which have been read much too sweepingly since the New Deal Revolution of 1937, and I'm referring, of course, here to the Commerce Clause and the Necessary and Proper Clause. If one looks as a textualist and an originalist at the original meaning of the phrase commerce among the states, it's actually fairly easy to figure out what that meaning is. The Latin roots of the word commerce, as my handout indicates, are com, which means with, and merce, which means in various forms buying and selling. The root merce in the Commerce Clause always appears in other English words as having an economic connotation. Consider here the English words mercantile, market, and mercenary, all of which also derive from the same Latin root merce, which appears in the Commerce Clause. The Commerce Clause thus only applies to activities where there is buying and selling among the states going on. It doesn't apply to possession of items or to transactions that are voluntary and don't involve buying and selling. The other grant of national power, which is often said to be sweeping and limitless, is Congress's grant of power under the Necessary and Proper Clause. That clause empowers Congress to regulate wholly intrastate commerce and, on occasion, possession as a means toward the end of effectuating Congress's power under the Commerce Clause. The Necessary and Proper Clause does constitute a major grant of power to Congress, and frankly, probably 95% of all federal laws and regulations, including almost all of the federal criminal law, are based on the Necessary and Proper Clause. So the clause deserves some attention. The first big limit on congressional power under the Necessary and Proper Clause is that the clause only authorizes Congress to use means toward the end of executing some other enumerated power. Chief Justice Marshall said as much in McCulloch against Maryland, and this is an explicit requirement of the constitutional text. The second limit is that while the Necessary and Proper Clause does grant Congress the power to use new unenumerated means to make effective the other enumerated powers, this does not authorize it to use any means it chooses. First, the means Congress chooses must not be so major that they ought to have been on the federal list of enumerated powers. Two examples show the context and limits of congressional power here. I believe that Congress can, under the Necessary and Proper Clause, set up an Air Force and a space-based military defense system. Doing these things is a proportionate means toward carrying into execution Congress's power to raise an army, provide a navy, and to declare war. Congress cannot, however, set up a massive government-run single-provider healthcare system because, as 5 Supreme Court justices said in NFIB against Sebelius, the power to centrally run a sector of the economy that constitutes 17% of our GDP and to control people's personal health care choices and access to doctors and to medicine is so large that it cannot plausibly be described as being a means to a constitutionally enumerated end. The usefulness of an air force to our Army and Navy is obvious and beyond dispute, but the usefulness of socialized medicine to some other enumerated power is dubious at best. Second, let's assume that a law is a means for carrying out an enumerated power and does not involve the exercise of a major power that one would expect the Constitution to have enumerated separately. In order for that law to be valid under the necessary and proper clause, the law must still be both a necessary and proper means for carrying out the enumerated power. Chief Justice Marshall famously construed the word necessary in McCulloch versus Maryland to mean convenient or useful to, but he didn't say anything about what constraints the word proper puts on congressional power. Two recent Supreme Court majorities have held that a federal law that invades the sphere of state power is not a proper law. 5 justices agreed as to this point in NFIB against Sebelius, and 5 justices so held in Justice Scalia's opinion for the court in Prince against United States, a case in which Congress tried unconstitutionally to conscript state government employees into doing federal work without their being paid for it. Prince and Sebelius illustrate as current governing law that Congress cannot usurp state power under the necessary and proper clause because doing so is improper. I now want to add the point that infringing on personal liberties and fundamental rights is also not proper, and so Congress cannot do those things either. Could Congress properly pass a national ban on the use of birth control or a national ban on the so-called offense of sodomy? I believe the answer to that question is no. Laws of this sort are quite simply not proper in an Anglo-American culture steeped in liberty. You do not need the Bill of Rights to ban such laws at the federal level, since Congress has no enumerated power to pass them in the first place. The laws I just described do not carry into execution an enumerated power, and the means used by such laws are so major that they ought to have appeared on the list of federal enumerated powers in Article 1, Section 8. The means used by these laws are highly intrusive on liberty, while the Article 1, Section 8 end they promote is extremely attenuated at best. It may be the case that if one aggregates all the use of birth control and of sodomy in the nation per Wickard v. Filburn, there's some kind of effect on commerce. But the effect is too distant and too out of proportion to the means used for federal power to exist here. This understanding of the word proper in the necessary and proper clause conforms to the etymological origins of the word as revealed in the Barnhart Dictionary. The word proper comes from Latin directly, the word proprius, which means one's own, particular, special, peculiar, of uncertain origin. The word proper in the necessary and proper clause thus allows Congress to use means to accomplish an enumerated powers end, so long as they're adopted or appropriate or proportional to the purposes and circumstances of the accomplishment of an enumerated powers end. The text of the Constitution also protects liberty, of course, through the Bill of Rights, the first 8 amendments and the 9th Amendment, and it protects liberty under the 14th Amendment, I think particularly through the Due Process Clause, through the Privileges or Immunities Clause. The Privileges or Immunities Clause provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. I think that clause is modeled on similar clauses in the Articles of Confederation and in Article 4, Section 2 of the Constitution. The clause in the Articles of Confederation reads as follows: the better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states. The Article 4 clause says the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So how would an ordinary literate American have understood the Privileges or Immunities Clause in 1868 when the 14th Amendment was enacted? They would have assumed that the amendment made binding nationwide the protection that Article 4, Section 2 provided to out-of-state citizens temporarily resident in or traveling through another state. Article 4, Section 2 obligates the states to give out-of-staters the same civil rights under the common law, state statutory law, and state constitutional law as is enjoyed by in-staters. Out-of-state travelers can be deprived of the political rights to vote, run for office, or serve on a jury of the state they are temporarily traveling through. They can also be denied access to state parks, state colleges and universities, and access to rake state oyster beds, as was famously held in Corfield against Coryell. But out-of-staters must be given the same civil rights as in-state citizens under Article 4, Section 2, and after 1868, it became unconstitutional to give a class of citizens like African Americans lesser or abridged civil rights as compared to those given to white Americans. Privileges or immunities are not natural law phenomena, but are instead created by state law. The English word privilege has two Latin roots, prive meaning private and leges meaning law. A classic privilege is thus the right of an English nobleman to be tried by a jury of his peers. A classic immunity would be the freedom of a nobleman not to be tried by a jury of commoners. The classic text on the meaning of the Privileges or Immunities Clause is the passage of Justice Bushrod Washington's in Corfield against Coryell, where the justice says the inquiry is what are the privileges and immunities of citizens in the several states. We feel no hesitation in confining these expressions to those privileges and immunities which are in their nature fundamental, which belong of right to the citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this union from the time of their becoming free, independent, and sovereign, which means 1776. I think that what that suggests is that rights that are deeply rooted in history and tradition that date back to 1776 are fundamental rights that are constitutionally protected. I thus agree with the Supreme Court's opinion. I agree with the Supreme Court's outcomes in Washington against Glucksberg and McDonald against City of Chicago, but I would have based those opinions on the Privileges or Immunities Clause, not on the Due Process Clause. In my view, there's no such thing as substantive due process. I think it is indeed, as John Hart Ely called it, an oxymoron like green pastel redness. But that is not the end of the inquiry, because I think that the Privileges or Immunities Clause does have a very libertarian original meaning that encompasses both one's federal and one's state privileges or immunities of citizenship. And that's illustrated in part by some of the history I now want to discuss. At the time of the American founding and Reconstruction, there were three powerful currents of opinion about liberty that were widely being discussed. First, the framers thought that they possessed the traditional rights of Englishmen and that they were being abused and cheated out of these rights by King George III. Second, the state bills of rights in the 1780s strongly suggest that the framers themselves were very libertarian. And third, the libertarianism that was widespread in the state constitutional law in the 1860s, when the 14th Amendment was written and ratified, suggests that that amendment too should be read through a libertarian prism. Prior to 1776, Americans were Englishmen, and they thought they were heirs to a long centuries-long tradition of liberty that went back to Magna Carta, but also to the years before the Norman Conquest in 1066. Colonial Americans were followers of the constitutional history of England offered up by Sir Edward Coke during his struggles with the Stuart despots, King Charles I and King James I and King Charles I, both of whom believed in the divine right of kings. Coke and his many followers countered these claims of absolute royal power with a theory that England had an ancient constitution of liberty that dated back to the laws of King Edward the Confessor, the so-called Leges Edwardi. I will first discuss Coke's theory of the ancient constitution of liberty and then explain why it's relevant to American constitutional law. Coke thought that England's ancient constitution of liberty had its roots in the forests of Germany, where, as the Roman historian Tacitus explains, the German tribes governed themselves with a remarkable degree of democracy. The Roman historian Tacitus confirms this account of the democratic libertarianism of the Saxon tribes in Germany. The author Trevor Colburn, for example, has said, quote, Tacitus's Germania enjoyed a remarkable vogue in the 18th century in colonial North America. John Adams read Tacitus frequently. Jefferson would enthusiastically tell any inquiring student to look to Tacitus as the first writer in the world without a single exception. Under this ancient constitution theory that Sir Edward Coke really developed, the Saxons brought their democratic and libertarian ways with them when they conquered England, and those rights therefore date back to time immemorial. Many of the Coke argued that some decisions were made by a group called the Witenamoget, or by the Witan, or by the Folkmoots, which were seen as predecessors to the House of Lords or the House of Commons. And the thesis essentially was that the last Anglo-Saxon king, Edward the Confessor, supposedly codified all these ancient Anglo-Saxon liberties in the Leges Edwardi. This theory of English legal history is criticized by English legal historians as being inaccurate as a matter of English legal history, but it's still very relevant to Americans because it's what Americans believed about English legal history. Americans believed Coke, followed Coke, and took to heart his belief in the ancient Constitution. And I won't go over all the various events in English legal history whereby the fight over Coke's ideas was maintained, but suffice it to say that England in the 1600s went through one civil war and then a bloodless revolution in 1688. And at the end of that, Sir Edward Coke's views about the primacy of the ancient Anglo-Saxon constitution substantially prevailed. But the main relevance of the English belief of the colonists' belief in the ancient constitution was that those were the rights they thought they had against King George III and Parliament. The Massachusetts Bay Colony was founded in 1628, and it was settled by Puritan dissenters from the Church of England, all of whom worshipped Sir Edward Coke and hated King Charles I. During the 1630s, when there was a great migration of 20,000 Englishmen from England to Massachusetts, the migrants were all Puritan opponents of Charles I and followers of Sir Edward Coke. My own ancestors in New Haven, Connecticut, in the 1660s, after the restoration of the monarchy, helped to hide 3 members of the Parliament that had sentenced Charles I to death from English troops that were trying to capture them, and those 3 members of Parliament were never found. As to Massachusetts, continued throughout the 1600s and 1700s to seethe with fervor for the ancient Constitution. And it's not surprising that resistance to English efforts to tax Americans was strongest in Massachusetts, which had been settled by Coke's supporters and where the Boston Tea Party occurred. The British reaction to the Boston Tea Party was to announce that it was closing the port of Boston and placing the city under military rule. That led to the battles of Lexington and Concord, which in turn caused the other 12 of the original North American colonies to rally behind Massachusetts' view as to the liberties of Englishmen in North America. Thomas Jefferson said that under King George III, the North American colonies had replaced the yoke of the Norman oppression with the yoke of a Hanoverian oppression. Trevor Colburn writes that American colonists in the 1760s and 1780s presented an idealized version of an Anglo-Saxon democracy, which they usually found overturned by Norman treachery and feudalism. In American eyes, English medieval history settled into a pattern of periodic efforts to reestablish pre-Norman liberties. John Philip Reed observes that the ancient Constitution had been a central element of the pre-revolutionary debate from its beginning with the passage of the Stamp Act to its conclusion with the Declaration of Independence. Reed quotes James Otis as saying in 1764 that liberty was better understood and more fully enjoyed by our ancestors before the coming in of the first Norman tyrants than ever after, till it was found necessary for the salvation of the kingdom to combat the arbitrary and wicked proceedings of the Stuarts. I've spent so much time discussing the ancient Constitution because it's actually central to understanding the American Revolution and the Constitution under which we now govern ourselves. Prior to 1776, Americans were Englishmen and they thought they had the rights of Englishmen. And they believed that those rights were not the rights of a constitution that was in exile, but of a constitution which could be made real and forceful in their own day. The ancient Constitution of England was challenged in many times in 1066, in 1215 with Magna Carta, in 1641 with the English Civil War, in 1688 with the Glorious Revolution, and in 1776 with the American Revolution. And every time the ancient Constitution of Liberties triumphed. Thus, the American colonists thought they were the true heirs of an English Constitution of liberty and exile that went back to time immemorial and that was epitomized by Edward the Confessor, Magna Carta, the Petition of Right, and the Glorious Revolutions of 1688, and the writings of Sir Edward Coke. So, contrary to Judge Douglas Ginsburg, I believe that the US Constitution never went into exile, not even in 1937, although it has been challenged on occasion by the big government we have today. But the Constitution is our governing document, and while we should observe as a general matter stare decisis, when new big government challenges to our constitutional liberties are made, we must as a society reject them and fight for our constitutional liberties just as our ancestors did. My second point and closing point on the original libertarianism of the framers of the Constitution considers the distinctive way in which those framers wrote their state bills of rights. In May of 1776, George Mason wrote the first draft of the Virginia Declaration of Rights 2 months before Thomas Jefferson wrote the Declaration of Independence. The first article of the draft read as follows: that all men are born equally free and independent and have certain inherent natural rights of which they cannot by any compact deprive or divest their posterity, among which are the enjoyment of life and liberty with the means of acquiring and possessing property and pursuing and obtaining happiness and safety. George Mason's first draft was adopted in slightly altered form by the Virginia Constitutional Convention in June of 1776. In the Declaration of Independence, Thomas Jefferson rewrote the first clause of George Mason's draft to say, quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." Thus was born the American Creed of Liberty. Most of the 7 of the 14 state constitutions that were in effect in 1791 had born free and equal clauses in the state constitution. For example, the Massachusetts Constitution of 1780 began with the following words. Article 1, all men are born free and equal and have certain natural, essential, and unalienable rights, among which may be reckoned the right of enjoying and defending their lives and liberties, that of acquiring, possessing, and protecting property, in fine, that of seeking and obtaining their safety and happiness. In fact, it turns out that 59% of the American population in 1791, when the Bill of Rights was ratified, lived in states that had Lockean natural rights guarantees in their state constitutions. This is a huge supermajority of the population living at that time. So now I want to close by describing how the libertarianism of the American founding, informed by England's ancient Constitution of Liberty, also informed the original meaning of the 14th Amendment, which was ratified in July 1868. An important window into the rights it protects is provided by looking at state bills of rights. Just as the states define what is the property that the Takings Clause protects, so too do the state bills of rights define the fundamental liberties that the Privileges or Immunities Clause protects. States cannot give state constitutional rights to white citizens without also giving them to African American citizens. A state can abolish its public schools by so amending its constitution, but it cannot maintain them in a discriminatory fashion. In July 1868, 24 out of 37 states had Lockean clauses in their state bills of rights. Those states included California, Delaware, Florida, Illinois, Iowa, Kansas, Louisiana, Maine, Massachusetts, New Hampshire, Nevada, New Jersey, Ohio, Pennsylvania, South Carolina, Vermont, Virginia, and Washington and Wisconsin. Lockean guarantees in state constitutions generally mimicked the language of the Lockean clauses in the original state bills of rights from 1776 on. They all say, in essence, that all human beings are born free and equal and have certain natural, essential, and unalienable rights, among which may be reckoned the right of enjoying and defending their lives and liberties, that of acquiring, possessing, and protecting property, in fine, that of seeking and obtaining their safety and happiness. What does it mean to say in practice that the Lockean clauses are incorporated into Section 1 of the 14th Amendment? It means that Americans have a constitutional right to enjoy life, to enjoy liberty, to acquire and possess and defend property, and to seek and pursue happiness and safety. The American people remain, according to our state constitutions in the present day, committed to the Lockean clauses of the framing and of Reconstruction. I looked at state constitutions in 2010 because I like to do number counts of things in state constitutions, and discovered that as of 2010, 31 out of 50 states have Lockean clauses in their state constitutions. This includes the states of Alabama, Alaska, Arkansas, California, Colorado, Florida, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Kentucky, Maine, Massachusetts, Montana, Missouri, Nebraska, Nevada, New Mexico, Ohio, Pennsylvania, New Hampshire, New Jersey, New Mexico. I mentioned that already. North Carolina, Oklahoma, Utah, Vermont, Wisconsin, and Wyoming. So my conclusion is that an original public reading of the Constitution and of its amendments leads inexorably to many, although maybe not all, libertarian outcomes. I think the ancient Constitution that Sir Edward Coke believed had been given to the English people by Edward the Confessor had a tremendous sway over colonial Americans. I think when colonial Americans wrote these Lockean clauses into half of their state constitutions in which 59% of the people lived in 1791, that those were the rights retained by the people of which the Ninth Amendment speaks of. And I think that the fact that 24 out of 37 states in 1868, when the 14th Amendment was ratified, had lock-in clauses in their state constitutions means that it's very easy to know what is the right that's deeply rooted in American history and tradition. The right that's deeply rooted in American history and tradition is the recognition that all men and women